Today's question: what debts must be paid in probate during Florida, and particularly focusing on the concept of known creditors. When someone dies, it's not like a jubilee where all the debt is forgiven and everything goes away. The law provides very specific rules and procedures about, what the personal representative has to do regarding debts, what the attorney representing the personal representative has to do regarding debts, and some very clear rights about what creditors have and obligations on both sides of the fence. But the bottom line is this. Key thing in probate is identifying what assets are coming in: house, cars, stocks, bonds, that sort of thing. And marshaling those assets and understanding the rules for each one of them is a critical function in determining who gets paid all along the way. So we got things like spouses that are entitled to be paid, minor children that have some interest, creditors. This is the biggie that I want to talk about here. And this is if someone owes you debt and they die, you got to understand what the rules are and how to go about protecting yourself. Now, this is particularly the case, like, say, business disputes and things like that. So, you're in business with someone, the guy's dying. You may trust the wife, the spouse, whatever, and think you're going to get paid, but not always the case. So you want to protect yourself. So there are things like caveats to be filed that puts everyone on notice. There are other obligations to reduce down that debt into writing if necessary. But an oral contract on a debt is just as enforceable in a probate as if the person were alive, particularly when they were acknowledging and working under that debt while they were alive. But there's very specific waterfalls, we call it, of how debts are paid, and cost of administration and medical bills and all these other things are right up there at the front end. Then we get into family allowance and then child support. But then these other debts come right down at the bottom. But securing that repayment of debt is really critical. And a critical thing to know, let's talk about on the creditor side of things. If you're owed debt and someone's sick, or you're owed debt and someone's ghosting, you're afraid they might be going to die. You may wish they were dead if they're not paying you back. But identifying that debt, making sure it's well known, acknowledged, is a critical part, particularly when we go in to litigate this thing in the context of a probate case. But this concept of the reasonably known or ascertainable creditor is critically important. One of the things that is a duty and obligation on the part of the attorney, personal representative, is to search for reasonably and known creditors. We have a secret weapon in here we've been deploying recently. I've gotten licensed on a piece of software that really helps to identify these debts and take care of all these responsibilities and check our boxes ethically and make sure we're properly administering the estate. It's a database system that has tracking for all financial systems. So we've uncovered assets we didn't know about, long lost accounts in different states, retirement accounts, other things the decedent's forgotten about. But we're also searching carefully for debts, and that means pulling credit report and doing some other credit searches to make sure that the estate is administered properly and the personal representative isn't subject to claims or clawbacks or removal action because they weren't following their job. So dealing with the creditor claims is a critically important function of probate. And if this is of interest to you, please like, subscribe, check in, and ask for our free report.